Hello, everyone. Thank you again for joining today's webinar on climate justice and the movement of state tort litigation against the fossil fuel companies driving global climate change. I'm David Flores, Senior Policy Analyst for the Center for Progressive Reform. Before we begin today's discussion, please allow me to introduce our presenters. Alexandra Klass is the Distinguished McKnight University Professor at the University of Minnesota Law School and a member scholar with the Center for Progressive Reform. Professor Klass's scholarship and teaching include topics in energy law, torts, natural resources, and property. Noah Oppenheim is the Executive Director for the Institute for Fisheries Resources and the Pacific Coast Federation of Fishermen's Associations, which is the largest commercial fishing industry trade organization on the West Coast. Mr. Oppenheim is a marine biologist and policy expert and a former commercial fisherman. And we have Karen Sokol, who is Associate Professor of Law at the Loyola University New Orleans College of Law and a member scholar with the Center for Progressive Reform. Professor Sokol's scholarship and teaching includes topics in environmental law, climate change, torts, and products liability. She is a co-author of CPR's recent report on state climate torts, climate justice, state courts, and the fight for equity. To begin, my first question is for you, Noah. How did you, your organization, and its members come to bring a lawsuit against not one, but dozens of the most powerful and wealthy fossil fuel companies in the world?
Thanks, David, and thanks to all of you for joining us today. Our organization, and indeed our members, experienced a profound economic impact in 2015 and 2016 that caused them to lose the opportunity to pursue their livelihoods for a period of 5 months. And while that in a former time may have been an abstract concept, certainly these days, I think many of us can envision what it might be like to lose our livelihoods for months at a time. But the causal factors that led to that economic impact, losing fishing opportunity in the Dungeness crab fishery in California, was not driven by an unpredictable set of events like a global pandemic. It was driven by predictable events that, in fact, were known to be an inevitable result of the combustion of fossil fuels, known by fossil fuel corporate executives, shareholders, etc. And those impacts were driven by warming ocean temperatures. You don't have to be a biological oceanographer or a marine scientist to understand the connections, but I'll walk very briefly through that. Warming oceans causes the excessive proliferation of a toxic marine algae. That algae produces a toxin called domoic acid, which, when expressed in high concentrations, winds up in the tissues of crustaceans like Dungeness crabs. When those toxin levels exceed health advisory thresholds, fishing cannot occur. In 2015, for the first time, those levels of domoic acid exceeded the FDA's health advisory. It was an unpredictable event driven by the blob, which was a persistent elevated sea surface temperature off the West Coast. That resulted in those excessive levels of harmful algal productivity and resulted in fishermen and women being prevented from going to work for 5 months. It resulted in tens of millions of dollars in economic harm to the California commercial crab industry. And in every year since, at least some part of the coast of California or the West Coast has been delayed from opening in the Dungeness crab fishery. Now, the reason why our organization has embarked on this course of holding fossil fuel companies to account is a reflexive one. The fossil fuel industry knew that catastrophic ocean warming was a result of the continued persistent combustion of fossil fuels, and our membership experienced financial harm as a result of that. So we are holding them to account using the justice system, which is indeed the remedy by which one in a trade organization or in an industry holds another harmful industry to account. We see the daunting challenge of this, and yet we feel that this is a perfectly reasonable course of action to take in order to get the recourse that we are due to receive because of those impacts and because of the harm that commercial fishermen and women on the West Coast have experienced for years and will likely continue to experience.
Thank you, Noah. So I'm personally familiar with how climate change is harming residents of my hometown, Baltimore, through flooding driven by more intense rainfall and sea level rise. And increasingly, many are recognizing that there is also a social equity dimension to how the risk of harm from climate affects residents in Baltimore and in other cities. For example, there's a link between historic redlining and disinvestment in minority and low-income neighborhoods that contributes in part to an increased risk of harm from extreme heat and air pollution worsened by climate. But the people in Baltimore are not the ones, even those most socially vulnerable to climate change are not those who are bringing lawsuits against the fossil fuel producers. Indeed, it's the city, like other cities in California, that is suing on their behalf. So my next question is for you, Karen. Can you introduce us to the history and current status of the lawsuits by local and state governments against fossil fuel companies, while also explaining what these governments hope to achieve for their citizens?
Sure, and thanks everyone for joining. So in this first slide that I have, interestingly, a little over a decade ago, the UN Intergovernmental Panel on Climate Change predicted that there would be a worldwide, what's now known as climate litigation movement. Essentially that the IPCC and others realized that the worsening climate crisis and continuation of inaction would lead to resort to judicial systems worldwide. Now, around the time of this report, there were a few cases filed in the US. They were filed by several states and an Alaskan village bringing claims based on the federal common law of nuisance against fossil fuel industry actors, seeking redress for climate harms. These cases were ultimately shut down by the US Supreme Court. The short of it is the court held that because the Clean Air Act is federal legislation authorizing the EPA to regulate greenhouse gas emissions, that federal legislation trumped any federal common law. But what's important about that decision was that it noted that the decision didn't have any impact on any potential state law claims. And if the entities wanted to file in state court, they could. At that time, none of those plaintiffs decided to do that, but Baltimore's case, Rhode Island's case, New York's case, Colorado's case, most recently Hawaii's case, NOAA's case, are all based only on state tort claims for that very reason, because of the federal common law problem. So they are, and they're also mostly filed in state court. So the number of these current cases that are just based on state claims far exceed the number that were filed earlier, a little over a decade ago. And the IPCC turned out to be quite prescient. So the next slide, slide 2, maybe not. So there's a report by the Grantham Institute on Climate Change and the Environment that is on what is now known as a global movement of, oh, here it is, climate change litigation. And it called it a global phenomenon in its most recent report. So they've been filed all over the world. So far, the vast majority have been filed in the US, and most of those are these state tort claims, like the one that Baltimore has brought. So I think the significance of the pace of this expansion can't be overstated, because it's a clear indication that not only people are seeking to push governments and fossil fuel industry to take action in the face of continued failures, but also that the harms of the climate crisis are being felt more acutely, and thus communities not only in Baltimore, Washington, Hawaii, but all over the world are seeking to hold actors accountable and to get some sort of redress for the harms they've suffered. So in each complaint, and if the next slide, I have some language from the complaints, because I think what's interesting, although this is a global crisis that is impacting the entire planet, the harms are of course faced at an individual and a community level. And in the complaints, they detail what the specific entities are suffering. So I just took an example from the West Coast. So this is the San Mateo case, and the harms that are alleged are mostly related to sea level rise. Now, an interior state like Colorado, it's things like, and I have language from that complaint when it comes, but it's things like reduced snowpack, very ecosystem specific impacts like bark beetle outbreaks, and things like that. So again, although it's global, these catastrophic losses are being felt all over at a very local level. The other important thing, thinking about the strategy and the status of this litigation right now, to get to the second part of that question, is that they both of these cases are based on longstanding tort claims. In the next slide, I have some language from those claims. 5A, yeah. So unlike federal common law, state tort law, as a well-developed claims, including nuisance and products liability claims, that can be used to hold corporations accountable for deceptive manufacturing and marketing practices. And that's what all these recent cases are based on. In contrast, the federal common law claim were based on these companies' emissions. That's not the basis of these claims. It is their systematic production of products that they knew were dangerous since at least 1965, coupled with a systematic disinformation campaign to continue profiting from those, notwithstanding what they knew. So this is a really important part of it. Additionally, one of the greatest challenges for these cases have been showing a causal link between the defendants, that is the corporate actors' conduct in production and marketing, and specific climate impacts. So the second part of this claim illustrates the sort of causation evidence that they now have. So beginning in around 2014, there were these two really important developments in this area called attribution to science. And essentially it allows plaintiffs now have at their disposal tools to do two things. So one is a particular catastrophic event, like a wildfire, a hurricane, a heat wave, particularly severe flooding event, can be tied with near certainty to the climate crisis. The likelihood is. And then the second is the attribution science, in the sense of being able to tie the products produced by a specific company to the percentage of greenhouse gas emissions, global greenhouse gas emissions. Put those two together and you're able to tie corporate business activity to specific catastrophic events and thus to the entity's losses. So you see that in San Mateo's complaint in the second paragraph there's a specific percentage. Now this case is against 26 fossil fuel industry actors, so it's a significant portion of the emissions, but as a result, the causal nexus is much tighter than in previous cases. So you see both of these developments laid out in these complaints in great detail, and they're over 100 pages each, so you can only imagine what they're going to find out if they're allowed to proceed to discovery. However, we haven't gotten there yet in terms of their status now. The big question is, will this pretty powerful litigation strategy have its day in court? The defendants, understandably, are fighting very hard to keep it in federal court, where they expect it will get dismissed, just like the fate of the earlier cases. And that question is likely to get to the Supreme Court.
Great. Thank you, Karen. My next question is for you, Alex. With the exception of Boulder, Colorado, all of the lawsuits to date have been brought by cities and states, entities like NOAA's on the coasts. Is there potential for litigation by cities and states in the Midwest? And why have those lawsuits not been brought? And what would the damages look like for those jurisdictions?
Thanks, David, and it's great to be part of this webinar. So I think there is definitely potential for lawsuits by Midwestern states and cities. I think the reason that you haven't seen it so far is a combination of the nature of the impacts and the politics. So in terms of the nature of the impacts, a lot of the focus nationally connected with climate change harms have been on sea level rise, hurricanes, these sort of large events that hold the national news for a long time, whereas the impacts in the Midwest are going to be somewhat different, but they're certainly no less catastrophic. So damages from flooding, we have a slide up right now. We seem to have 100-year floods every year. And the impacts are just hundreds of millions of dollars each year. So with regard to both Minnesota, my state, as well as other states in the Midwest, you have damages from flooding, you have significant impacts on infrastructure, transportation, water supply, wastewater treatment, and the power system. And those are as bad or worse as some of the ones that you would have on the coast in terms of impacts. You have health costs from extreme heat events, and particularly up in the northern part of the country, reduced extreme cold. You need extreme cold to deal with allergy issues, asthma issues, vector-borne diseases, to make sure that pests and other things die in the winter. And that does not happen as much in northern climates. The Midwest is home to a huge amount of agriculture. It's a big, big part of our economy. And we're not just talking about future damages to agricultural yields. We have those now. We already have dollar amounts for these climate-related damages. Damages to the forestry sector are significant as well. Minnesota has a big winter tourism industry in terms of snowshoes and snowmobiling, big losses to tourism and outdoor recreation because of the inability to engage in winter sports, hunting, fishing. So there are fishing issues as well in the Midwest, as in addition to on the coast that Noah talked about. There's pretty significant threats to indigenous communities with regard to disruption to their livelihoods, health, cultural identities, and just general changes in ecological systems, plant and animal species. And economists and others have placed dollar numbers on the losses that have already been incurred, and they've been incurred in large part by states and local governments who are addressing those problems, as well as trying to prevent losses in the future. So those are the nature of the harm and the damages, which certainly exist in the Midwest and would support lawsuits as well. So why haven't those lawsuits been brought? Part of it is politics. You have cities and states, the politics on the coast tend to be less hesitant to take on the fossil fuel industry, but it's not as if city mayors and state attorney generals in the Midwest are ignoring these issues. So at my school, the University of Minnesota Law School, our Student Environmental and Energy Law Society hosted a very well-attended conference in the fall that was entitled "The Legal and Scientific Case for Recovering Climate Change Damages in Minnesota from Fossil Fuel companies, and lots of members of the legal community and city governments and state governments were there. Our Attorney General, Keith Ellison, spoke at that event, and we had as speakers Vic Scher, attorney from San Francisco, who's representing most of the state and local governments in the existing lawsuits. We had experts from the University of Minnesota, an applied economist, and one of our public policy professors talk about the science and the policy behind these lawsuits. And we also had an attorney in town who was one of the lead attorneys in the $6 billion tobacco litigation back in the 1990s. And basically the lawsuits that exist today are really modeled in large part after the lawsuits in the 1990s seeking damages from the tobacco companies. So we sort of tied all those issues together in this conference. So there is a lot of focus on these lawsuits and these claims. They haven't been filed yet, but I wouldn't be surprised if states and cities in the Midwest began to join these lawsuits. Many of the attorney generals in the Midwest have signed on to amicus briefs in the existing suits and are following the litigation very closely. But we certainly there's certainly an interest in the Midwest, and there's certainly significant damages that would support claims as well.
Great, thank you, Alex. My next question is for both you and Noah. What role do or even should state climate torts play in the domestic or international strategies to address climate change and to promote a transition to a clean energy economy?
Well, thanks again for the question. It's important to point out here that PCFA v. Chevron, our litigation, is not about solving climate change. It's about seeking a remedy for the actions of another sector or group of actors that harms our members. In this case, it's the oil industry, and it's about a response to corporate malfeasance that's known to have caused that harm. That said, mitigation for the impacts of a warming ocean and more acidified ocean by fishing communities is already taking place, and it is certainly part of the remedy that we are seeking in filing tort litigation against fossil fuel companies. Those strategies and changes are palpable, though they are real, and they are costly to our members. And certainly being able to hold companies to account for their actions that have harmed others in the form of compensatory damages, which we are seeking in our litigation, is part of the way that we ensure that the entities that are causing this harm are held to account for it. And certainly if other sectors that identify those harms and can attribute those costs through attribution science or through other mechanisms are able to then quantify it, then certainly that would be well within their rights as participants in the American judicial system. Certainly when we recognized the harm that we were experiencing, the immediate and natural recourse is to seek damages from those who are causing it in the tort system.
So Noah raises some excellent points that build on what Karen had said earlier, in the sense that these particular lawsuits, they're not trying to engage in climate regulation. They're not trying to force governments to regulate or to act in a particular way. They are very traditional tort lawsuits to recover damages for harm that has occurred through the conduct and misconduct of, in this case, the fossil fuel companies. So their actions that they have taken, and as well as misconduct in terms of covering up their own knowledge of the harms of continued use of fossil fuels. And that has resulted in a large part of the harm that we're seeing right now that Noah's group has sustained, and that city and state governments have sustained as well. And it's seeking financial redress for that. So they're very traditional tort lawsuits. But to build on that, if you take kind of a bird's eye view of where litigation fits in with other approaches to energy transition, you can see that there's some, you can focus on the demand side and you can focus on the supply side. So in terms of the tools that we have to engage in energy transition and to move towards a cleaner energy economy, one of the things that you want to do, of course, is to promote renewable energy and clean energy. So you can do that through tax incentives, you can do that through subsidies, but you can also focus in on the supply. And one of the ways you focus in on the supply is, of course, to promote the supply of renewable energy, but then also to disincentivize in different ways the fossil fuel industry, since that's what's causing the harm. And one of the ways to do that is through lawsuits. Another way to do that is through influence on investors, and so that's happening in other areas. And so really all of these in some ways are different policy tools that work together. But in this particular case, when we're talking about lawsuits against the fossil fuel industry, these really are traditional tort lawsuits to recover concrete damages that have been incurred and will be incurred.
Excellent. Thank you both. So I see a question from our audience, which anticipates the next one for you, Karen. So earlier you talked about how domestically and internationally climate litigation in general has grown over the last 10 years. And I'm wondering if you could talk a little bit more about some of those other cases that are not state climate torts, but may influence or be influenced by state climate torts. So more specifically, how do the state climate tort lawsuits fit into this larger climate litigation movement? And in particular, will they be impacted by or impact the fate of other climate suits in the United States, specifically the Juliana case, and then also the case brought by Massachusetts against Exxon for violations of state consumer and investor protection laws?
Sorry, I was muted. So good question. Thank you. I have a slide giving kind of before this one, giving a sense of the worldwide litigation to pull back from the US, and then I'll address that. So around the world, there's two categories of suits. One is against governments. Those are based on constitutions and international laws, also some state-specific statutes in cases. And then second, suits such as the ones we're discussing today against fossil fuel companies, and they're based on common law and statutes. Now, the number against national governments far exceed the number against fossil fuel companies. And going to those first, those are essentially against governments either for a failure to act on climate as a result of rights claims based in the national constitutions and or international law, or a failure to enforce existing statutes. It varies. I have highlighted some of the countries in which the high courts have issued some particularly important decisions, and the US is highlighted double because we're here. There have been two cases filed against the US government. One is Juliana, the litigation that a lot of people have probably heard of and that you asked about. Recently, there was a case filed by several Louisiana tribes as well as the Alaskan village that filed that initial case back in the early 2000s with several UN high commissioners, High Commissioner on Human Rights, High Commissioner on Refugees, alleging that the US government is failing to protect them and they're facing displacement as a result of the climate crisis. Now, the suits against fossil fuel companies, the vast majority have been filed in the US, and they are the state tort claims that we're talking about today. If these eventually get to trial, I expect to see a lot more elsewhere in the world. So it'll be interesting to see how that plays out. In terms of the other US cases and how they might impact the climate tort cases, the short answer is they should not, as a matter of doctrine, but the industry is using them and arguing that they are all related. Essentially, the industry's argument, whether it's in Massachusetts and the claims based on consumer protection and investor, and similarly, the US government is arguing the same thing. The idea is courts have no business addressing a global problem, much less providing any sort of remedial measures for it. It is for the political branches, Congress and the executive, to address, if at all. That's it. There's several doctrines that they're using, but that's what their claim boils down to. In the Juliana case, the Ninth Circuit panel that heard that agreed with the government's, that argument on the part of the government. It's really not relevant to the state tort claims, but Ted Boutros, the attorney for Chevron, promptly filed a motion in the Ninth Circuit, which is currently hearing all the California cases to decide which court they belong in, saying that Juliana required that court to dismiss all the California cases. So it is being used, and we'll know after the Ninth Circuit issues a decision whether it works. And in terms of the Massachusetts case, that's an interesting one because it's not based on state tort law, but it's based on consumer protection and investor protection statutes. And the consumer protection statutes are much like products liability and the public nuisance claims that the suits against the common law suits, the climate tort suits. They're based on the company's deceptive manufacturing and marketing and seeking redress for that. That case came out differently from Juliana, so the fossil fuel companies made the same argument, but the court held that they did belong in state court. So we have several of these decisions in lower courts that are going one way or the other, and that's another reason it'll probably eventually get to the Supreme Court, because the industry will fight this to the Supreme Court.
Great, thank you. Alex, earlier you mentioned in describing the conference that you held at University of Minnesota Law School about a speaker who brought some perspective from the tobacco torts litigation during the 90s. And I'm really interested in learning more about parallels between historic movements in state tort litigation, lessons learned, how they relate, obviously, to state climate torts in particular. And I'm wondering also, in addition to asbestos or tobacco, for example, if you could talk a little bit more about the present strategy by state and local governments that are seeking to hold pharmaceutical manufacturers and distributors accountable for the opioids crisis, and how that might relate to the ongoing state climate torts litigation as well.
Sure. So Minnesota is the only state that they along with other states brought lawsuits against the tobacco companies. The Minnesota one was brought by the Minnesota Attorney General's office and also Blue Cross and Blue Shield. And those were for damages that the state and that Blue Cross Blue Shield incurred in terms of treating tobacco-related harms. And these were consumer protection claims. And Minnesota actually has very strong consumer protection laws and consumer fraud laws. And the Attorney General in particular has a lot of authority under those laws to bring those suits. It's the only one of these lawsuits in the country that went to trial. The trial took several months, and then it settled while the jury was deliberating, and it settled for $6.6 billion to the state and Blue Cross Blue Shield. The tobacco companies continue to pay significant amounts of money every year to the state of Minnesota for tobacco cessation projects and pilots and other sorts of things. And a lot of this was reimbursement. And so we had Roberta Walburn, who was one of the lead lawyers for the state counsel help with the litigation. Um, and she saw a lot. She spoke at our conference and saw a lot of parallels between the fraud and deception connected to the tobacco companies, why that supported consumer protection claims, and that very similar to the actions by the fossil fuel companies in this case. So a lot of the parallels between the tobacco litigation and the climate damages litigation is going to be over those consumer protection claims. Obviously, a lot of the states also have, most of them also have products liability claims as well, and nuisance claims, but several of them in some of the states that have filed, or cities that have filed, have brought consumer protection claims, and there's some very good parallels to the tobacco industry there. With regard to the opioid lawsuits so far, those have been brought also by cities and states, and those have tended to be nuisance lawsuits that parallel also very well the nuisance claims that have been brought in the climate damages cases. So once again, you have an industry that knew about the harms of their products and hid that in order to continue to make profits off of those products. It's in states like Oklahoma and Ohio that have actually, had the most success to date in these lawsuits. And so I think those also serve as a model. Once again, you're using long-standing tort doctrine to seek damages for different types of harm, whether that be nuisance or products liability. And I think the climate damages suits have a lot of parallels to those claims.
Great. I'm going to anticipate another question here from one of our participants directed to you, Noah, about litigation in general, whether that is something that's new for your organization. But I also want to know a little bit more about what the experience has been like for you and members, certainly in the Pacific's fisheries and members of your organization that have been harmed by climate, and especially those folks who are involved as plaintiffs in the litigation, what their experience, what their reaction has been, and if you could also provide any insight on sort of the experience or reaction from their families, the fisheries industry at large, and then also the local communities that depend on these fisheries and these businesses to thrive.
Thanks for the question, David, and to the panelists the attendee who asked it. I did, as you were beginning to ask, finish typing a limited response. In that response, there is a link to our complaint. So the specific issues related to the compensatory damages that we are seeking can be found there. And the short answer is that we are seeking financial redress driven by those specific financial harms that were done to individual commercial fishermen up and down the West Coast, in California and Oregon specifically. The experience that West Coast commercial fishing communities have had in the last several years has been, for many, to be cataclysmic, catastrophic. Right now, certainly the evaporation of the restaurant market and the export markets are causing extraordinary damage to fishing communities now. But this comes on top of extreme environmental harm that's been done to Western watersheds and rivers in particular. Our organization is quite litigious. In fact, we're not new to litigation by any stretch of the imagination. We've been suing state and federal agencies for quite some time because of the incredible harm that excessive divergence and the violation of the National Environmental Policy Act, the Endangered Species Act, Clean Water Act, et cetera, does to commercial fishermen downstream of excessive divergence or agricultural pollution impact to rivers and anadromous fish in their freshwater environments. The tort litigation, this liability claim that we are making in PCFA v. Chevron, those are new claims. This is a new approach to litigation for our organization, but is certainly not new to us. I'm not an attorney personally. I'm quite attorney adjacent, but we've been suing the bastards for quite some time. Now, in terms of what this means for commercial fishermen and their families and their communities, it's been, as I alluded to earlier, disastrous. The results of the 2015 and 16 closures were existential to some fishermen. Many left the industry because they were unable to float it through that period. We received commercial fishery disaster assistance for those closures in 2019. So the disaster assistance came far too little too late at about maybe 20 to 25% of the overall economic harm that was experienced that year. So we are clearly not supporting commercial fishing communities or coastal communities to the degree that we need to in order to ensure their survival in response to environmental harms like harmful algal blooms, in order to keep our nation's domestic sustainable seafood supply alive. And this is one of many of PCFFA's efforts to ensure that externalities like global climate change, agricultural pollution, excessive diversions of rivers don't unduly impact the fishing industry.
Thank you, Noah. So we're now going to begin our question and answer segment of the webinar. For participants, at the bottom of your screen, there's a menu with the Q&A box. You can type questions in there. The first question I'd like to start with is one I'd like to actually pose to all three of you. The participant asks, is there any litigation happening or anticipated from southern states? I'm very interested to learn that as well, but I also ask you to maybe take an even more expansive view. I'm really curious, and one of the things that I'd like to follow is where others see additional state climate tort lawsuits in the future. So with respect to specific geographies like southern states that you might be looking at, from your experience with fisheries management and fisheries science, for example, or in your work following attribution science in general. And then lastly, any particular events, hurricane storm events, recent or prospective extreme weather of some kind. I'd like for you each to talk a little bit about where you expect the next sort of crop of state climate tort lawsuits to come from and why. I think with that, maybe Karen, could you start, please?
Yeah, that's a really good question. It's the South is a region that, well, since I'm here, but just generally given the impacts, I've been really curious about. Although I don't expect any state governments to bring any of these suits, it's possible that localities will, in particular cities. I haven't heard of any actually in the works, but I know a lot of people would be interested in that. I think although Honolulu just recently filed a case, a lot of entities or people thinking about potentially bringing suit are likely waiting. There's the Fourth Circuit Court of Appeals just held that Baltimore's case belongs in state court, but the same question is pending before the Ninth Circuit, the 10th Circuit, and the First Circuit. And it's possible that once we get a few more decisions keeping them in state court, we'll see more filed.
So I think it's important to keep in mind that there's a lot of resources that are required to bring a suit like this, either a state attorney general's office or a city attorney. Even if you're going to outsource it to a private attorney, you still need a lot of engagement General's offices and cities. And so I think Karen is right that other states and local governments are going to be looking to see what happens in these cases and take the lead and, maybe file amicus briefs. And then if those cases, the ones that are pending right now, seem to go well, then to file later. And you don't really need to reinvent the wheel, and can build off the good work of what sort of the early actors have done. But I also agree that I think, at least when you're focusing in on the South, it's going to be cities for the most part rather than states, just simply because climate change has become so politicized. And you're going to have cities that are more interested politically in taking on the fossil fuel industry than you are states. But one exception to that at some point might be the state of Virginia, which certainly has significant climate impacts, has just enacted legislatively a 100% clean energy bill. And so it's possible that both the politics and the impacts might align in a state like Virginia to want it to take action that way. I would think, if any state in the South were to act, Virginia might be the most likely, again, because of the politics there versus other states, and the fact that it doesn't have a really strong in-state fossil fuel industry like Karen's state.
Noah, could you talk a little bit about, from your perspective as a fisheries science and management expert, where else do you think quite possibly there might be, already climate harms occurring to fisheries and fishery communities, but possibly the likelihood of future state climate tort litigation?
Certainly. It's a question I receive frequently. Generally speaking, I'll separate my answer into two parts. The last part first, which is, I'm a little bit reluctant to speculate on where additional litigation could be developed here. I'd encourage anyone who feels like it's their right and responsibility to access the justice system in order to hold an external actor to account for causing harm to them to do so. Now, the other part of the question is, where are environmental drivers that are known to be associated with global climate change and global warming and ocean warming impacting coastal communities? And certainly we see an increasing frequency of both unpredictable events, including ocean heat waves, as well as both acute and persistent biological events associated with decreased pH in the ocean, so ocean acidification as a broad catch-all. And that in particular is impacting the shellfish industry. Oyster growers on the West Coast in particular are watching our case carefully, shall we say. The early indicators are coming in that larval crustaceans are to some degree physiologically and perhaps metabolically impacted by low pH. Now, certainly that's not, that's alarming. It's not being experienced yet, as far as we know scientifically, to the degree where we would see an impact to commercial harvest of crustaceans, crabs, lobsters, etc., on the West Coast. Similar indicators exist, by the way, on the East Coast and in other fisheries. So it's a global phenomenon impacting crustaceans, certainly potentially at the individual level, quite possibly in the future cascading up to the demographic or population scale. So we're certainly watching out for those potential changes, but global droughts, the increasing persistent dry conditions in the West, which then of course impact anadromous species like salmon, those are things that we're certainly experiencing and are certainly keeping an eye on, let's say.
Great, thank you. So the next couple of questions from our webinar participants concern really the Supreme Court and where climate litigation goes to next in the Supreme Court. So specifically with the Juliana, the potential for an appeal, and really in terms of a larger strategy for holding fossil fuel interests, holding the government accountable to protect youth and future generations specifically. And also, what are the prospects for that litigation, of course, given the makeup of the court as it is today? What could we expect litigation to look like, and what might be the first case the Supreme Court hears next? So Karen and Alex, would you like to answer that question?
Sure. So yeah, that's a really good question. In the Juliana case, the plaintiffs have already filed a petition for rehearing en banc with the Ninth Circuit. So that will be the first step. I don't know, but I expect that they would file. There's a good chance they might file with the Supreme Court if that gets denied, or if the Ninth Circuit panel grants it and then upholds the panel's decision. If the full Ninth Circuit were to reverse, I know the fossil fuel industry would appeal to the Supreme Court. The problem with that, the Supreme Court, the current court, in the history of the Juliana litigation, the government has filed a number of pretty extraordinary motions. They're called emergency motions for stay, all the way up to the Supreme Court. So there were a couple times at which it looked like they were actually going to go to trial in the district court. But it's really got shut down by the Ninth Circuit because the Supreme Court essentially, in an opinion denying that motion for emergency stay, signaled to the Ninth Circuit, if you don't hear this, then we're going to grant this. So that there's been an indication that the Supreme Court, if it heard this, would likely agree with the government. If that were to happen, there are still a number of avenues. What's interesting about that litigation is that similar suits have been filed in several states based on state constitutional rights versus federal constitutional rights. So it's the same thing on behalf of future generations. And a lot of these state constitutions have much stronger language regarding rights to a clean, healthy environment, that are good for human and other species well-being. So actually more environmental, human rights related, explicit, versus our Constitution, where the right is much more vague, and that argument is harder to make. So any Supreme Court decision that would not have an impact on any of those state cases. So that's still an avenue against the government versus the industry.
Yeah, I agree with everything that Karen said. In terms of the Juliana case and trying to actually force governments to act, there is an effort to get to the entire Ninth Circuit en banc, but certainly there's not a friendly Supreme Court waiting on the other side of that. And so on the federal level, in terms of imposing federal limits or forcing the federal government to act, a lot of that is through elections, through Congress, through legislative action at the present time. But at least with regard to the courts, I think state constitutional law, I agree, is promising, and state common law. So I mean, that really does show some of the distinctions between the climate damages suits that are very much based in well-developed state tort law and just applying that to a new set of facts, rather than the cases like the Juliana case, which it can more easily be described as making the court do something new. as opposed to just applying long-standing tort law or consumer protection law to this particular.
Great. I think we have time for about one more question. This one's directed to you, Noah. I'm going to read it verbatim. Hi, Noah. I grew up in the commercial fishing industry in Alaska and now go to law school at the University of Minnesota. My experience has been that fishermen can oftentimes be incredibly individualistic or averse to resorting to government processes. I'm curious how much of a challenge this is presented in developing your case and how your organization has worked to develop unified representation of the fishermen in this type of litigation.
You're pointing to a series of issues. Thank you for the question. That any
No problem.
Thanks, Siri. Apologies. A series of issues that everyone faces in our industry in particular, and I don't want to dive too deeply into a fishing industry specific conversation. So I'll zoom out just a little bit and talk about unifying a disparate group of stakeholders to collective action in order to take on a politically difficult task like the one we have in PCFA v. Chevron, which is seeking accountability for a massive set of impacts with geopolitical overtones. It's a challenge, and certainly our organization has a long history of existence. It was founded in 1976 with a litigious streak that allows us to communicate with experience and a good track record why taking legal action is important in order to support our members. They've seen their rivers polluted and diverted for generations. They understand full well that legal recourse is incredibly important for areas like Alaska, which have much more of a libertarian streak, or for the Midwest, for example, where those kinds of collective action or the sorts of too little too late last resorts in order to just cling on to hope and existence may not seem palpable at this moment, are nonetheless being discovered. And you can look in Alaska, it's not climate litigation, but many groups for the first time are finding that the travesty of the proposed Pebble mine in the headwaters of the most productive salmon fisheries in the world are worth commencing litigation over. And as more and more communities experience the kinds of climate-driven challenges or pollution-driven challenges that California commercial fishermen have, they may choose to take these kinds of actions as well. But it takes hard work. It takes a lot of time to develop rapport with an industry in order to be able to represent them in a case like this. But the work is worth it. Certainly for PCFFA, being able to support our members in this regard is validating and humbling, but the challenge remains.
Excellent. Thank you, Noah. So we have reached the end of today's event. I'd like to thank our presenters, Karen, Alex, Noah, and everyone in the audience for joining us today. As we close out the webinar, you'll see some additional resources and ways to get involved on your screen. Remember that the webinar recording will be available soon, and please complete the participant survey to share your feedback on today's webinar. Also, please do not miss our webinar next month, where we'll hear from science and policy experts working to address climate hazards, social vulnerability, and disease. Thank you again for joining us.